This is the Senate Transportation Housing Committee. We'll start our meeting. We have a lot of bills. We have 4 members here now. We can start, and we'll wait the other members to attend so we can achieve a quorum. But we'll start hearing legislation at this point from our presenters. And first of all, I'd ask that you turn off your cell phones in this room. Take your conversations outside. Because we want everybody to hear the testimony of the people testifying. And we have 4 bills that have been removed from our agenda. I want to announce them up in the front of the meeting here. This is the Senator Hancock's bill, SB 1277, 1278, 1279, and 1280 have been pulled from today's hearing. So if anybody's here for those bills, we will hear them at a later date, probably next week. We have one item on our consent calendar, that's SB 944. Also, as you can see by our agenda, after the committee has reviewed all and voted and disposed of various bills, the committee will also vote on whether or not to grant a reconsideration for Senator Liu's SB 876. You might recall that Senator Liu had this bill presented last week and did not achieve the sufficient votes. And the vote today is a vote to allow the author to bring the bill up at a later date. Today we will not vote on the bill itself, but just simply whether or not we want to allow the author to bring the bill up at a later date. So we're not voting on the bill, but just allowing her the courtesy of reconsideration. So first author is Senator Jerry Hill. Jerry Hill, please come forward. We have our bill, item number 1, SB 812, Jerry Hill, Charter Park Carriers. You have the floor, Senator.
Thank you, Mr. Chair and members. I'd like to accept the amendments listed in the excellent analysis and want to thank the chair for his input and direction. SB 812 seeks to improve the safety oversight of buses. Countless Californians travel millions of miles every year by bus, and last November, a runaway tour bus crashed in Union Square in San Francisco, injuring 20 people, 7 critically. The crash and the potential for brake failure caused me to look at the state's current bus inspection program to see how that could happen. What I found were some problems that I'm seeking to fix through this bill. After the crash in Union Square, the CHP conducted a surprise, unannounced inspection of the company's bus fleet, discovering 61 violations, 29 of which were for equipment issues. These violations had not been identified in previous scheduled inspections. While surprise inspections are clearly effective, nothing in current law requires surprise inspections unless a carrier's fleet is more than 100 buses. In fact, most inspections are scheduled, giving time for bus carriers to fix safety problems before the CHP arrive. That's why SB 812 directs the CHP to do more surprise, unannounced inspections. In addition, under current law, bus carriers with a record of safety compliance are inspected as often as carriers who have a history of safety violations, meaning that the CHP's valuable resources aren't used as effectively as possible. I want to make sure that we use the CHP's resources strategically and that the inspection program is risk-based by targeting carriers with questionable safety track records. To that end, SB 812 creates 2 inspection schedules. The first is for bus carriers with a history of non-compliance and safety problems. These operators will be inspected every 6 months until they improve their compliance with safety standards. The second inspection schedule is for carriers with a track record of safety compliance. They will be inspected every 2 years. This 2-track inspection schedule means the CHP will focus more of their efforts and limited resources on problematic and unsafe bus operators. Our research also revealed that under current law, buses assigned an unsatisfactory rating are given a full 4 months to fix the safety violations. This is clearly too long. My bill shortens this time period, so any bus that receives an unsatisfactory rating will be re-inspected within 30 days. We also discovered that bus carriers pay only a $15 inspection fee, which was set in 1986 and hasn't been changed since. The state covers the rest of the cost, ranging from $300 to $400 per bus. To help balance this out, the bill directs the CHP to raise the inspection fee to cover the cost of the program. The bill caps the fee so no carrier pays more than $6,500 for their entire fleet. I know this proposed fee increase concerns the bus industry. They have told me that they are open to paying an increased fee, but would prefer that the fee be set in statute. Moving forward, I would like to work with them, the CHP, and our fiscal committees to see if that is possible. The Union Square crash also helped reveal that under current law, used buses, when purchased by a new carrier, do not have to be inspected prior to be putting into service. SB 812 closes this loophole by requiring that used buses purchased by carriers with a history of safety issues first be inspected by the CHP before being allowed on the road. Lastly, our research revealed that under current law, a bus carrier can be given multiple consecutive unsatisfactory ratings by the CHP and still operate. To tighten this, SB 812 will implement a rule that puts bus carriers out of service if they get 3 consecutive unsatisfactory safety ratings. To ensure due process, carriers will be able to request a review from the CHP and have a hearing at the CPUC. A carrier's license will be reinstated upon a satisfactory reinspection by the CHP. Thank you, members, for your indulgence, and if I have a witness.
Thank you, Senator Hill. We have a quorum. I'd like to take roll now. Call the roll, please.
Senator Bell?
Here.
Bell here. Cannella?
Here.
Cannella here. Allen? Bates? Here. Bates here. Gaines? Galgiani? Leyva? Leyva here. McGuire? Mendoza? Here. Mendoza here. Roth? Here. Roth here. Wachowski?
Okay, we have a quorum. Thank you. Witnesses, please, in favor of this bill, please. Thank you.
Mr. Chairman, members, Josh Pana on behalf of the California Bus Association. We've been working with Senator Hill on this particular bill. We're just about there. We're supporting his overall effort. We think that one item, as the senator had mentioned, this idea of the fee, that we should have some sort of cap in statute. The cap was at $15, but that's basically for a third of the fleet that is inspected. So it really is a $60 fee because they're only inspecting a third of the fleet every time they come out and inspect. But that $15 fee is paid each time. We applaud the author's efforts overall. We think it's a good approach. We think one aspect is we've talked about the idea of putting it as like the commercial truck fee, and we think that that too could be important to look at as a model. There's actually a cap on that in the commercial truck fee scale, and we think that could be our particular model as well. So we've talked to the author about that, and we appreciate his efforts. Our association has been on the forefront of safety. We pushed the Dave Jones bill, which was a one strike and you're out for a carrier. That is, if you do put a driver on the bus without the proper licensure, you're out, you're revoked. So we appreciate the senator's efforts. We actually had talked about the idea of having a bus inspection every 13 months. Many of the carriers in this association have their buses inspected every 13 months. We think that would be the highest of standards. So we applaud the senator's efforts and would urge your aye vote on this measure.
Thank you. Other witnesses, we're talking in favor at this point. Yes, sir. You can use either mic. Please come forward.
Mr. Chair and members, Michael Pimentel here in support on behalf of the San Francisco's Mayor, Ed Lee. We apologize for not having our letter in yet, and we very much appreciate the efforts of Senator Hill and his colleagues to improve the safety of charter buses operating in California. And with that, we ask for your aye vote.
Thank you.
Mr. Chairman, members, Mark Watts representing the San Francisco County Transportation Authority. Our board just took an approved position on this, support position on this measure, and we're here to ask for your aye vote.
Thank you. Any additional witnesses in favor? If not, do we have witnesses who would like to testify neutral or opposed? Anybody that wants to testify, please come forward. I see none. Questions up from the committee? Any questions? Senator Hill, you have closing remarks?
Respectfully ask for an aye vote, members. Thank you. And I want to thank the California Bus Association as well. They are just a great partner to work with on every issue that we have, and they truly are concerned about safety.
Thank you. Do we have a motion on this item? Okay, we have a motion to approve the bill with the amendments. It goes to Energy Committee. And no more questions. We'll call a roll, please.
The motion is do pass as amended and refer to the Committee on Energy, Utilities, and Communications. Senator Bell?
Aye.
Bell, aye. Cannella?
Aye.
Cannella, aye. Allen? Bates? Bates, aye. Gaines? Galgiani? Leyva? Leyva, aye. McGuire? Mendoza? Mendoza, aye. Roth? Roth, aye. Wachowski. So, 6-0.
We have 6 votes in favor. We'll keep the roll open for absent members. Senator, thank you.
Thank you, Mr. Chair. Thank you very much, members. Appreciate your consideration.
We'll go to item 2. Senator Jackson is here. Senator Jackson, welcome. We have SB 868, State Remote Piloted Aircraft Act. And Senator, you have the floor.
Thank you, Mr. Chair and members. This is SB 868, a bill that establishes a basic set of sensible and intelligent regulations regarding drones that strikes a balance between protecting the public safety, our privacy, and our wildlife, while still encouraging exciting innovation and technology. This is relatively new technology. It has many potentially wonderful and innovative aspects to it, but it also does challenge what we as a society can and should expect as we move forward in a future full of technological changes. The development of small unmanned aircraft systems, either called unmanned aerial vehicles, remote piloted aircraft, or simply drones, promises to revolutionize the way Californians interact with each other and their environment. This technology could transform the way California's farmers and ranchers manage livestock and agricultural resources. Right now, innovators in California are figuring out how to design drones with high-resolution cameras and sensors that allow farmers to engage in precision agriculture, targeting the applications of pesticides, fertilizers, and water to be used only where they are needed, which not only lowers the costs of producing food, but substantially reduces the likelihood that herbicides, insecticides, and fungicides will end up in our waterways. Very exciting, potentially terrific uses for this new technology. But drone technology could drone technology could also fundamentally alter the way goods move across our state and greatly improve the capacity of our emergency personnel to respond to disasters. And drones will enable news-gathering organizations to capture compelling images and footage that was impossible or too expensive to do just a few years ago. However, the lack of clear rules governing the use of this emerging technology threatens to undermine public safety and to harm California's natural resources. To date, the lack of regulation on drone use has led to disputes between neighbors concerned about invasions of privacy, with people literally shooting drones down in their neighborhood in violation of other laws, and of course in threatening and endangering neighbors as well as themselves. It has interfered with wildlife, creating conditions amongst animals and wildlife where they believe that they are being attacked by predators. Impacts to wildlife near collisions with airplanes and helicopters. We have seen incidences where a medevac helicopter was almost struck by a drone, which would have caused a very serious tragedy up in the Fresno area. We've seen interference with firefighting efforts in Los Angeles and accidents injuring innocent bystanders. to name a few of the problems that we've seen. Some individuals are reportedly modifying drones to carry weapons, and in at least one instance, a drone was used to land radioactive material on the roof of a government building. The list of potential pluses and minuses is virtually limitless. Irresponsible or even dangerous operators and their drones simply should not be able to threaten our safety, our private property, and the critical infrastructure we need to keep our state running, or our beloved state parks and wildlife refuges. Nearly every day, we hear of another potentially dangerous or destructive incident involving a drone, and we cannot, we should not, we must not wait for a disaster to strike before setting clear, common-sense rules that provide certainty for everyone while keeping the public safe. SB 868, the State Remote Piloted Aircraft Act, implements these common-sense rules, ensuring that drone use does not harm wildlife, does not threaten critical infrastructure, does not undermine privacy interests, or become a platform for the deployment of weapons. Among other things, this measure limits drone use within 500 feet of critical infrastructure, within 1,000 feet of a heliport, or within 5 miles of an airport without permission. And I might indicate, people have said 5 miles of an airport. That is actually an FAA regulation that exists. California would just simply be aligning itself with that federal regulation. It limits disruptive drone use near private property. It limits drone use over state parks, wildlife refuges, the state capitol, or other designated safety areas without a permit or permission. So if you are a commercial drone user and you have a reason that you want to fly a drone over the state capitol, if you obtain permission, you'll be able to do that. As far as our state parks go, I would like to indicate that the federal government has already prohibited the use of drones over our national parks. We would expand that to include our state parks. It prohibits the weaponization of drones, for obvious reasons, and it prohibits the reckless operation of drones and drone interference with manned aircraft. And it requires commercial drone operators to obtain liability insurance, commercial drone operators. This measure continues to allow local governments to regulate drone use in their communities and provides exceptions for skilled operators who have received authorization from the Federal Aviation Administration to fly in otherwise restricted areas. It also avoids the threat of frivolous litigation by vesting primary authority with the Division of Aeronautics, which is within the Department of Transportation. And the bill directs the Division of Aeronautics and other state agencies to work cooperatively with local governments and the federal government to enforce this regulatory framework. We have Tim Cromartie with the League of California Cities and others here today to testify in support of the bill and help answer any technical questions you may have. This is an issue whose time has come. The FAA anticipates that there will be 7 million drones by the year 2020 that will have been purchased in this country. To give you a sense of that, to date we have 500,000 airplanes in this country. We will have 7 million drones. What do we do? With that, I would ask for your consideration and your aye vote in this matter and pass it along to our witnesses to testify.
Okay, witnesses in favor, please identify yourself and make your statement.
Mr. Chairman, members, Helene Meshar on behalf of the City of West Hollywood. The City of West Hollywood supports SB 868, and it wanted to let you know that the city adopted its own ordinance regarding drones earlier this year. 868 complements that ordinance, and we're pleased to see that the state is taking on the issue of regulatory oversight for and framework for the for this area of the law. So we are in support of the bill. Thank you.
Other witnesses, please.
Mr. Chairman, members, Tim Cromartie on behalf of the League of California Cities. We have a supportive amended position currently. We've been working with the author regarding suggestions for fine-tuning the local control language. Our understanding is she will be taking that language, so we will look forward to soon being in unqualified support of the bill. SB 868 goes a long way toward establishing the kind of comprehensive regulatory framework for unmanned aircraft systems that we need in this state but do not yet have, particularly in light of the relatively lightweight FAA regulations. We do not believe that the needs of the private sector should outweigh the need for aviation safety, public safety, or local regulation in this area, particularly in view of the many incidents in the past 2 years that have indicated a growing danger not only to first responders, but to commercial aircraft. Thank you.
Other witnesses?
Chair and members, Jonathan Feldman with the California Police Chiefs Association. We don't have a position on the bill, but we have been very supportive. We supported SB 142 last year, and we appreciate the Senator's continued effort to address the public safety concerns that have been raised by drones in each of our cities. We look forward to continue working with her and her staff. We've had a lot of great dialogue between our association and their office, and look forward to developing the rules and enforcement of those rules to make sure that our cities are safe.
Pam Loomis on behalf of the San Diego County Regional Airport Authority, which operates the San Diego International Airport, in support of this bill. The San Diego International Airport has experienced several incidents of drones either flying on or near the airport property, and they're very concerned about the public safety of the passengers and pilots coming in and out of their airport.
Witnesses in favor, please come forward and testify.
Thank you.
Yeah, go ahead.
Kelly Doon on behalf of California League of Conservation Voters in support.
Okay. Other witnesses in favor? If not, can we have the witnesses opposing come forward, please? Speakers opposing this measure? Come right up here and have a seat and present yourself to our committee.
Good afternoon, Mr. Chairman, members of the committee. My name is Doug Johnson. I'm Vice President Technology Policy for the Consumer Technology Association, 2,200 member companies spanning the breadth of the industry. About 80% of our members are small businesses and startups, and that is certainly represented in the drone space. We're strongly opposed to Senate Bill 868. Contrary to the spirit of this legislation, stated spirit, which is to encourage the development and general use of drones. On the contrary, we believe this bill will deter innovation and deter investment in California in this exciting new technology, which holds all the promise that you've heard earlier. We're concerned in three specific areas of this bill that needlessly addresses, it has provisions that needlessly address conduct already prohibited in California. It creates a new insurance requirement devoid of the actuarial support needed to impose those burdens. And finally, it has various provisions that are in conflict with the federal law. The privacy and property protections in this bill are redundant, but they go further than that and cause us concern because they create new causes of action related to those privacy and trespass violations that are already covered in California law. We're also concerned about the section in this bill that would give new carte blanche authority to the Department of Transportation to regulate drones and drone operators. And this is without regard to federal efforts that are going on now. And contrary to the testimony you heard earlier, there's actually a large number of activities going on relating to drones. Not the least of which are rules for commercial use that are expected in the first half of this year. I just finished serving with 25 other stakeholders in an advisory committee for the FAA recommending rules and performance standards for drones operating over people. There's also the registration requirement for drones, which was the result of a multi-stakeholder process last year. That's up and running and covering hundreds of thousands of drone operators and many more drones by that requirement. There's the Know Before You Fly campaign, which is about 2 years old, but that is important both before and after these permanent rules are in place, because consumer education of operators in the public and private sectors is crucial to this industry and to the safety of the airspace. And then finally, with respect to privacy, there's a multi-stakeholder process going on right now involving all sorts of perspectives at the national level through an agency of the Department of Commerce, and that will come to conclusion soon as well. So there's a wide variety of important issues being addressed in significant ways right now. I mentioned preemption. This bill would create no-fly zones, and only the federal government has that authority. It's certainly backed up by the Supreme Court and other court decisions over the years. But pursuant to that authority, FAA has designated appropriate uses, has designated no-fly zones under that authority already. The FAA came out with a fact sheet in December, which many states and cities have found helpful in understanding where the division is between federal jurisdiction and state and local jurisdiction. And I would urge you to reference that document, but they mention, and I'll close with this, that there are substantial air safety issues raised when state and local governments start regulating the national airspace. Thank you.
Thank you. Other witnesses, please.
Mr. Chairman, members of the committee, my name is Corey Owens, and I'm with DJI. DJI is the world's largest manufacturer of consumer and commercial drones. The primary message I want to leave you with is, contrary to some of the testimony that was provided earlier, industry completely agrees that this is an area where clear and concise rules are necessary, and public safety absolutely should be a priority. I'm fortunately not in the position where I'm here to tell you there should be no regulation. I think there should be, and I think the industry will benefit immensely from clarity in law. We simply disagree, and we do, with the approach taken in 868, and will encourage your no vote today. The author, the senator, suggested that this bill would align state law with federal law, and I will beg to disagree on a couple of important points. The first, as Doug from CTA mentioned, the ability to restrict navigation of airspace is generally limited to the federal government, and in particular, this is not just the federal government that asserts this, but actually existing California law. Article 2 of the California Aeronautics Act specifically says that the state respects that the right to regulate operation in the airspace and operation of aircraft rests with the federal government. Chapter 3 of the California Aeronautics Act goes further to say specifically that the sovereignty of the airspace is with the state and not any further down, specifically with the municipalities, as this bill would do. And so that's just to say that I think we do benefit immensely as a country, as a state, as citizens, when there is a harmonized federal airspace, and that has been recognized in federal law, in federal case law, and indeed in the California Aeronautics Act. The jurisdictional question aside, I would offer this. I think that any daylight between state and federal law in this area leaves California consumers and businesses in the lurch. The sponsor of the bill gave an outstanding summary of all the positive value that this technology can bring, but our suggestion is that this bill would make it very difficult for any California consumer or business to realize that potential. As one example, the bill would prohibit all flight within 5 miles of an airport without permission from the FAA. That's different than what the FAA suggests in their rules, and that authorization from the FAA is not possible to obtain. The FAA requires that if I'm going to operate an unmanned aircraft as a high school robotics club, let's say, that I have to notify the tower. That notification requirement in federal law is very different than an outright prohibition of flight that is proposed here. It is also at odds with what is being pursued by the American Association of Airport Executives, which includes the chief executives of all of the large California international airports. They are working with industry to establish a digital notification regime compliant with federal law and FAA guidance. Again, I do not dispute that we shouldn't have unmanned aircraft interfering with manned aircraft. I am fully in support of clear rules that provide clear guidance to California consumers and businesses. I think that largely the area to do that will be in federal law. To the extent that state law is required to empower local law enforcement, we will be supportive of that. Unfortunately, we believe this bill goes far, far beyond that and is likely to end significant innovation in this space in California, and as such, DJI strongly encourages your no vote on 868. Thank you.
Okay, thank you. Other witnesses, please.
Maria Garcia with Greenberg Traurig on behalf of State Farm Insurance, and we actually have an opposed unless amended position on the bill. We have some specific concerns related to the language providing for the exemption of those with FAA authorization, as well as what was previously mentioned, the mandate for commercial liability insurance coverage. So we have had an opportunity to talk with the author staff, and should the bill move forward today, we look forward to working with her on those provisions.
Okay, please.
My name is Bruce Parks. I'm representing the Silicon Valley chapter of the Association of Unmanned Vehicles, as well as a newly formed organization called the Drone Pilots Federation. And I'm going to have to agree with my colleagues here that while the author of this resolution bill fully understands the wonderful advantages that drones will bring to the state of California, where it's creating jobs and innovation, at the moment, the way it is written, it's too complicated, and I think that it needs more work before our organizations could support it. Like my colleagues, we certainly are not opposed to regulation, but it has to be regulation that makes sense and is not in conflict with existing federal laws and does not act as a lid on the development of the industry. Thank you.
Thank you. Other witnesses, please, back there.
Mr. Chair and members, Joe Devine on behalf of GoPro here today in opposition.
Mr. Chair and members, Jeremy Mers on behalf of the California Chamber of Commerce, also in opposition.
Mr. Chair, Chris McKaylee on behalf of CompTIA, the Computing Technology Industry Association, in opposition.
Good afternoon, Chair and members. Kate Bell on behalf of the Association for Unmanned Vehicle Systems International in opposition.
Mr. Chair, members of the committee, excuse me, Jim Ewart with the California Newspaper Publishers Association. We are not opposed to the bill. In fact, we want to thank Senator Jackson for working with us and providing her staff and his time in working with us to address our concerns. We've come a long way from when the bill was first introduced and understand that there are going to be amendments that are going to be put into the bill in the next committee. And we look forward to remaining neutral as a result of that. Thank you very much.